the state. On the show, great to have you join us. My name is Gabriel, new to Ankrah. Stay for details.
Oh yes, the solution to all your travel needs is here. Ankrah Lodge and Travel Services offers you the opportunity to travel to the following countries: Canada, United States of America, Turkey, Dubai, UK, Australia, New Zealand, Malta, Germany, and other European countries, where skilled workers such as nurses, paramedics, nannies and caregivers, drivers, plumbers, masons, electricians, carpenters, painters, etc. are needed for urgent employment. Ankrah Lodge and Travel Services can secure your Schengen visas with work permits. Individuals, organizations, churches, schools can contact us for their ticketing and hotel reservation, car rental services, international tour packages, travel consultation, visa assistance, and study abroad packages to all countries. We are located at Mr. Bates bus stop opposite the Calvary Baptist Church at Abaka, Accra, or contact us on these numbers: 0544 27 9525 or 0545 622 672 or 0302 237557. Ankrah Lodge and Travel Services, your destination, our pride.
Back. Let us settle for W Breeze. On W Breeze, what we do is to give you a sneak peek of the topic for the day. We're looking at everything surrounding the judiciary today. So judicial independence is a fundamental principle of democratic governance, ensuring that the judicial branch or arm of government is insulated from any form of interferences by the other branches of government or any external actor. That is what judicial independence grants, that arm of government in the performance of its actions or functions, nobody interferes with them. Ghana has had 15 Lord Chief Justices since independence in 1957. 15 Chief Justices. Ghana's current Chief Justice is Justice Gertrude Araba Isaba Saki Tokonu. She was sworn into office on June 12, 2023. She is the current Chief Justice of Ghana. On March 25, 2025, President of the Republic, John Dramani Mahama, through his spokesperson and Minister for Communications, Felix Fosukwachi, announced that he's received petitions seeking for the removal of the Chief Justice from office. The removal by the President. The press statement also informed the public that the President was forwarding the 3 petitions that he has received. He was forwarding them to the Council of State for the Council of State to commence consultation processes mandated under Article 146 of the 1992 Constitution. He received them, he forwarded them to the Council of State to commence the process. The statement further explained that the move of the President is in line with Article 146 of the 1992 Constitution. So the President is just abiding by the tenets of the law. The said Article 146 is that article that governs the processes for the removal of Chief Justice or justices of the superior courts, the Chief Justice, and other officers whose functions are analogous with justices of the superior courts. So that is what this article basically does. And the other officers that are analogous with the officers of the justices of the superior courts include the chairperson and the deputy chairpersons of the Electoral Commission, and then the chairperson of the Commission for Human Rights and Administrative Justice, and the deputy chairperson. So SHRAJ and EC, they are chairpersons and deputies. This Article 146 governs how they can be removed by a petition from someone to the president. Meanwhile, the Chief Justice has requested that the petitions that the president has received and forwarded same to the Council of State, she should be copied. She should see the charges that have been leveled against her as it is under the Article 146, Clause 6. She has to see those allegations made against her. The initiation of the processes that could lead to the removal of the Chief Justice, Gertrude Saki Tokono, from office has attracted varied views from lawyers and constitutional law experts. They are talking, interpreting, explaining what is happening. In the wake of the various controversies surrounding this petition for the removal of the Chief Justice, we ask, is the President of the Republic's action justified? And his action, are they legal and appropriate? Or the appropriate procedures have been adopted for what the President has set off to do? We'll dig into the issue. Stay with us.
Sorry, not sure.
Wake up to a purposeful day.
Get ready for a transformational morning experience.
Sorena Shrine is here to build our spirituality, mental and physical well-being.
Through positive, inspiring actions and stories.
We bring you exciting activities and conversations that develop us as a people and as a nation.
We take a look at the trending issues in Ghana and the rest of the world.
And we also review the impacting stories from our local newspapers.
Every morning, we bring you stories of hope, change, and renewal.
We empower you through the Word of God and provoke you to live the purposeful life destined for you.
Join us, Anita Kwaku
and the Reverend Ajika Vincent Agbamanya, Monday to Friday from 5:30 a.m. to 10 a.m. as we take you on an inspiring journey, live and exclusively on WTV.
You may also join us on Facebook at WTV Ghana and on YouTube at Wesleyan TV Ghana.
Sorry, not Shrine.
Wake up to a purposeful day.
Sorena Shrine is brought to you by
Danwell Insurance, Multi-Credit Savings and Loans,
and the Methodist University Ghana.
Praise God, praise God. Christ in tea, you respond, yeah, addition. I'm excited to announce to you, friends in the Lord, are you seeking for a platform where you can pray? Open baby up a soul bomb pie. Now ninyami edi in kita home. Bibi chiro so. And I'm maybe not the same kum. And you're coming home. Let's go into the prayer room. on WTV every Friday 9 p.m. to 11 p.m. to meet seasoned ministers of God that God has raised to impact your life. Remember, John Wesley said, I have too much to do, therefore I spend several hours in prayer in able to do it. That is why we are calling upon you. Meet myself, Reverend Hosea say, and the Evangelism Missionary Renewal Directorate as we lead you into the prayer room where we encounter Christ. And I believe your life will never be the same. Call your friends or loved ones every Friday 9 p.m. to 11 p.m. where we will encounter Christ. God bless you. See you on our screens on WTV every Friday 9 p.m. to 11 p.m. God bless you.
We pray that each and every one of us.
Welcome back. This is the state, and this afternoon you wouldn't want to move away from your set if indeed you've been following closely what is making every Ghanaian stay glued to know what is becoming of the judicial service or judicial system of the country. Everybody is keen on knowing what the president and the council of state and everybody who matters so far as this conversation is concerned. I'm referring to the petition that is seeking for the removal of the Chief Justice of the Republic of Ghana, Justice Gertrude Isaba Araba Saki Tokono. So the President of the Republic, through his spokesperson and Minister for Communication, Felix Ofosu-Kwakye, announced on the 25th of March that the President has received 3 petitions and he's forwarded same to the Council of State as mandated by Article 146 of the 1992 Constitution. So the Chief Justice has also come back strongly asking that if these petitions that are making charges against me, I have my rights to know what they are saying so that I could respond accordingly. We are looking at the petition and we are examining the move of the President. As he's received the petition, he sent it to the Council of State and asking the legality and appropriateness of the process that has been adopted. It promises to be an educative session and also very interesting. So you wouldn't want to move away from your set. We have in the studio a legal practitioner. Like I always say, we always have the people who matter in the space, authority on the subject matter, to help you, the viewers, to understand, to follow the conversation. JB Efrifa Esquire, he's a legal practitioner. JB, good to have you again on the show.
Thank you.
And then our viewers are glad that you're always on hand to help us break down the legal.
Yeah, thank you very much.
Great. We are joined also on the phone by, he is a socio-political analyst, Professor Nana Osei PC Anto. Prof, good afternoon and welcome to the States.
Thank you very much for inviting me to the discussion.
Our viewers are glued and ready to listen to you two, how you can help them understand what is happening currently in the country. Let me begin with Prof, if I may. Just let me begin with you quickly. Judicial independence. Do you think that we have it, our system, per what is happening, the context within which we are having this conversation? Is our judiciary independent?
Yeah, when you talk about independence, you see the point. People construe independence to be freedom. The two are different. So the framers of the Constitution were very careful not to have used the word freedom, but they used the word independence. And independence simply means that, yes, you are working within the confines as given you, but there should be supervision of what you do. Or you can be called to book. I hope you're understanding me as simply as that. So that within the confines of your profession, like you are working, there may be a general manager of your station, but you are using your professionalism and the terms of reference are given to work without any interference as to how you should do the work. But if there's any infraction, you could be called to book. If it were freedom that appeared in the Constitution, then it means you can do it the way you want, whatever. But even there, you are subject to the laws of the land. You see the point?
Yeah.
So you have your freedom to work without any interference in terms of let or hindrance or whatever. But even there, you cannot have that unfettered freedom without necessarily submitting yourself to the laws of the land. And the laws of the land, the key of it is the Constitution. So the Chief Justice has been given powers as independent. Because if you look at recently when the Speaker of Parliament, who is also independent in terms of the legislature, he was called to book.
So our judicial system is independent, but must be accountable. Is that it?
Yes. Yes.
So the independence is not in doubt.
Yes. So when it comes to the Chief Justice, we look at the provisions of the Constitution that may call for her removal as Chief Justice. And Article 146 says going, that is clause 6 going down, are explicit. And you see, when you are reading the Constitution, you see that once an article is given and clauses are given, it follows procedurally. That's what you call it's a process. A process is achieved by procedure. 1, then you go to 2, then you go to 3. And as it goes, it explicitly explains how that particular article or clause should be effected. So somebody I heard on radio today, and the person was saying that, yes, the Chief Justice may be right to call for a copy of the petition, but it is premature.
Okay, Prof, we'll get to the details of the conversation, the subject matter, as it were. So yeah, I'll come to the lawyer in the studio. But before I do that, do you think the happenings now, what we are experiencing, it's creating uneasiness in the judicial system?
It is not creating an uneasiness in the judicial system, but it's exposing what those who tamper with the Constitution bring confusion, exposing the confusion that those who don't follow the constitutional provisions or whatever power they get, and they want to do everything to inure to their benefit, the confusion that they bring in the system. And you have seen this presumably openly since Nana came to power. You see, I am just an analyst. It is not a fact, but it has been overemphasized during the rule of Nanado, which has created a whole lot of confusion in the system, which it must exhaust or exercise by the Constitutional Review Committee, who should do justice to the power given to them to review the Constitution and put things right once and for all, so that a president cannot, by his or her own whims and caprices, disturb the nation by some appointments and some overrulings and all that.
Okay, very well.
They don't order well for this country.
Okay, very well.
There must be a stop to it.
Thank you, Prof. Thank you, Prof. I'll come back to you again. Let me come to the studio, Lawyer JB. That is the system in which you operate. That is where you find yourself. So I'll give you a two-pronged question. First, where you are, the judicial system, is it independent? where you sit, your assessment, and then tell us what this Article 146 is all about.
All right, thank you very much, Annie. I would extend a warm welcome and, to your viewers and all of this. I would say, from where I sit, that our judiciary is one of the robust judicial systems you would ever come across. And it is indeed independent. Now, when Prof was given the meaning of independence, among other things, he said that, it's you being able to work within your confines, but it should be subject to some level of checks. Now, Ghana as a country, and as one of the principles underpinning our constitution, is the principle of separation of powers and that of checks and balances. However, there is something distinctive about the judicial arm of government, such that for them, it is not a matter of the legislature or the executive checking what they do. Their work is only subject to that of the constitution. And so the only standard to which we measure the efficiency or the conduct of the judiciary is by the constitution. And that's so clear in the terms of the constitutional provision that we have under Article 127 on the independence of the judiciary. And so the judiciary is not answerable to the legislature, it's not answerable to the executive. It is only answerable to the dictates of the constitution. And so from where I sit, the judiciary as it is independent, and it has been given the safeguards to operate in that manner, such that it is not so dependent on the legislature who come to government on the ticket of a political party, or the executive who also does same. It is the only arm that we do not see that you have to belong to a particular or come on the ticket of a particular party before you are appointed. However, the issue has been that with our constitution, it is the president that would appoint. But they take a judicial oath, which enjoins them to discharge their duties without fear or favor, even to their appointing authority. And so it is not to say that because party A or party B appointed a judge, they have sold their conscience to them and will do their bidding. They take a judicial oath, which is under the constitution, to discharge their duties without fear or favor to any political party. And so, in theory, under our constitution, they are independent, and in practice, they have been independent. One may disagree with a decision from a judge, but that does not mean that they are not independent or they are doing the bidding of one. In any given case, there are two or more parties involved. Definitely, it will go in favor of one person. And so the fact that a decision does not go in your favor under a particular government or otherwise does not mean that they are doing the bidding of the government of the day. It clearly means that the case has been determined on its merits. And let me say this, that constitutionally, no judge can be held accountable for their judicial opinions. And if I may read that for you in the clear terms, it says that a justice of, I'm reading Article 1273, a justice of a superior court or any person exercising judicial power shall not be liable to any action or suit for any act or omission by him in the exercise of judicial power. And so a judge exercising his or her judicial power is not answerable or cannot be subjected to any level of action, being it civil or criminal, for their judicial decision. However, it is only their administrative actions that will subject, because the Constitution and Article 125, which gives them the power to exercise and administer justice in this country, gives them, and they have to operate by some administrative decisions, being a human institution. And so it is only those things that would come to play. And under Article 146, you realize that the grounds for removal, it's only limited to 3 grounds. That it's a stated misbehavior, it's incompetence, or inability to perform by reason of infirmity, which can only be proven by a medical record, by a practitioner. And so it limits it to a stated misbehavior and incompetence. The incompetence is not that of a judicial decision that has been made, because as lawyers, I would prefer my opinion. A colleague of mine may prefer a different opinion. It doesn't mean any of us is wrong. It is our understanding, our appreciation, and the interpretation we place on any given matter. The matters that come to them are matters of fact, and they are matters of law. there are a lot of laws that would come into play. And so if a decision, I will make the point again that if a decision does not go away, or a judge is seen to be making certain decisions that do not favor you, it does not necessarily mean they are independent. They should be given that free room to operate. And so in all the hierarchy of the courts in Ghana, from the lower courts to the higher courts, I believe that there are a plethora of legal regime, a plethora of processes and procedures that have been put in place for them to operate without fear of favor, and they are independent.
Okay. JB, you mentioned the stated grounds, 3 grounds that Article 146 says that the Chief Justice can be removed, and the first one is stated grounds of misbehavior. It's not, President didn't tell us what the petitioners were looking. So now, what the general public, what is it? What has the Chief Justice done?
Yes. So it is for a reason, and for this time around, I think I should commend such a procedure. It's clearly in line with the procedural requirements of the Constitution that all proceedings, and proceedings has been interpreted in a number of cases, the GBA and AG Aban case, Mutaderi and Tiger IPI, that all proceedings means that all processes in relation to this procedure for the remover. And so from the time of the petition itself, they should be held in camera. In camera means that it should not be revealed to the public. And so it is for this reason that I believe that to date, we have not seen who the petitioners are, though we are told there are 3 petitions and the content of the petition, because it's entirely for the perusal of the person appointed by the Constitution to deal with such a matter. And so the petition for the removal of either a justice of the Superior Court or the Chief Justice, and for the purpose of what we are discussing, the Chief Justice, it should go to the President. And then who would, as the settled position of the law has been established, would establish a prima facie case. A prima facie case that there is merit in what has been presented to him. And after that, he would, in consultation with the Council of State, establish a committee of inquiry who would go into the matter and make the determination. It is for this prima facie issue that, I mean, a lot of people have raised concerns about, that you'd realize on the face of the Constitution it does not appear, but from the decision of the Supreme Court in 2006 from Frank Akwete.
No, it was Frank J.C. Chum versus the Attorney General. Bright Akwete was the one who filed.
Yes. So it was Frank J. Chum versus the Attorney General. That the court established that though it does not appear on the face of it, there is a logical gap, particularly to Article 1466, because when you read the provision 1463 in relation to a justice of the Superior Court, it makes it mandatory for the Chief Justice to establish a prima facie case before the committee of inquiry is established. And so it's only, it gives the impression that there was a gap that had to be filled by the courts in that case, that because you don't want a situation where any frivolous petition that's filed against a Chief Justice, a committee is formed to go into it. It means that the Chief Justice for the entire period would have petitions day in and day out, because clearly the literal meaning of Article 1466 would say that when a petition is presented to the President, he should go ahead to form a committee. And you realize that then they would keep having a number of these petitions, and always there are petitions, but that would be an affront to the intent of the framers of the Constitution, that the judiciary should be secure and independent, because it could be in any way motivated by any political group that we have to frustrate this Chief Justice. Let's send a petition, and the clear terms of the Constitution says that when we send a petition, the President should conduct a committee of inquiry. And you realize that the committee of inquiry for the Chief Justice consists of 2 justices of Superior Court and 3 other members who are just laymen, who are appointed by the Council of State in consultation with the President. And so it will not make the esteemed office of the Chief Justice so secure. And that is why there is a reason for a prima facie case to be established before that consultation is made.
Okay, Prof, let me pick your thoughts on that. You mentioned in your preliminary submission, Prof, you mentioned the word accountability, and that will let me connect to you being a political analyst, and of course following the social fiber and development in our space. Some private people have gone to court, Supreme Court, challenging this procedure or process. We've had a MP for Otafo going, and then we've had other people also going to say that there should be an injunction on the process that is going. The Chief Justice herself has asked for the petitions. People have raised the issue of natural justice and all that should come in. But in the history of our judicial system, Sir Akokosa, Chief Justice then, when first President Nkrumah was in power, Nkrumah sacked him. When after the Kulungugu bombing set up, the rulings was not in favor of the president. Is it that the Chief Justice is crying to the funeral house, or she is crying wolf, that it's really much ado about nothing? You are being held accountable, and the law provides that. Is that the situation we have?
That is
Prof?
like it's an
We have to work the line. I sense Prof is speaking, but we can hardly hear him. Prof Anto, Prof, if you can hear me, I'm asking about the accountability bit. We asking about accountability, the accountability you mentioned earlier. So we will work the line and get Prof back on the line. JB, let me.
Yes, I must say that the issue of natural justice, I mean, as a principle of law, natural justice comes in two forms. That you do not have to be a judge in your own case, and then you have the right to fair hearing. These are so fundamental and basic tenets of the law that we cannot do away with. Now, particularly in respect of the circumstances of this case, we are talking about the right to be heard. That if there is a petition against you for either a stated misbehavior or incompetence, the person who is involved should at least be heard on the matter.
JB, we have Prof. Let me pick this and then you give your angle. Prof, we lost you in a bit. I was asking about the Chief Justices asking to know the charges that have been brought against in the spirit of natural justice, and you mentioned accountability. I was linking it to that. Hello, Prof.
Yes.
Hello, Prof. Lawyer, you may continue with it.
Yes, so any person cannot be condemned without being heard. And the issue of the prima facie case, as I had already stated, is so crucial.
JB, just a minute. Prof, I hear you speaking. We can.
Okay, I'm hearing. I want to hear the other person. So let him go on.
You want to? Okay. JB, Prof wants to hear you finish your submission.
Yes. So the issue of natural justice, as I said, is so crucial that you cannot be condemned, or adverse findings cannot be made against you without you being heard. Now, earlier, Prof had hinted that the request of his leadership, the Chief Justice, is premature. That the petition has just been referred to the Council of State, and she's already asking. But you'd realize that, as I stated, and in reference to the case I stated, there is a prima facie case to be established. And when you read the constitutional provision, Article 146, clearly, the Council of State's role is only an appointing role. It's a role that they assist the president to appoint and constitute the committee. Clearly, in the Constitution, it is not for them to assist the president in establishing the prima facie case.
So who
it's entirely within the purview of the president. You see, I chanced on the Committee of Experts report that was submitted to the Consultative Assembly before the promulgation of this Constitution. And the earlier provision that was to be there was that, in respect of the Chief Justice, a petition will be referred to the Judicial Committee of the Council of State, who would establish a prima facie case. You get it? So
Yes.
it is the Judicial Committee of the Council of State who would have assisted the president to establish a prima facie case. Then the Council of State as a whole would now constitute the Committee of Inquiry.
That has been the case. That has been the case because Sam Okujeto, the Venerable Sam Okujeto,
Yes.
used to chair the immediate past Council of State Judicial Committee.
Yes, but I'm saying that on the coming into force of this constitution, that provision was not reproduced in the constitution as we have it. The appointing authority of the Judicial Committee and the establishment of the prima facie case by the Judicial Committee has now been changed to that of the president. So the constitution as we have it now, it is the president who has the mandate to establish the prima facie case. Though His Lordship Dateba in the 𝗟𝗓𝗩𝗘 case hinted that the president could do so with the Council of State. But that is not a clear position of the law as we have it in the Constitution. That was his opinion, that the president could not do that in vacuum. And so he may consult the Council of State. But in the clear terms of the Constitution, the Council of State only assists the president to appoint. And so the prima facie case ought to be established by the president. And it is prudent that before the president, because we don't expect an instance where the president will make a one-sided determination of the prima facie case. And so it is prudent that the respondent, that is the Chief Justice hearing, who is being accused of any of these grounds that we do not know about, is at least heard, because she forms the content is about her. And it is prudent and in conformity with the rules of natural justice that as a preliminary issue, her preliminary comments are heard on the matter. I think that's basic.
Very well. Prof, you had the lawyer, then
I had the lawyer. But we didn't all go to the law school. We went to school. Oh, sure. You see, as I said, any constitutional provision by article from clauses down expand the system for you to understand what should be done. And article 146 straight down gives that explicitly. The sex. Let's go down the sex. In the case of the Chief Justice, the president, in action, in consultation with the Council of State, so it is not the president's law, appoint a committee. So the appointment of the committee, if you say that is the president who may become a president by a political party, there can also be a president coming from an independent status, would not necessarily become the president of Ghana by or through a political party. And you see, sometimes our biases have affected even the workings of the Constitution, where you think that if one time president was so much gullible, another president will so much be gullible. But let's stress that a president is a president. You see, so in accordance with the Council of State, establish a committee. You see, that's the first instance. The committee appointed under clause 6, that is 7 of this article, shall inquire into the petition. Shall inquire into the petition. And then the 8 follows. You see, while they are inquiring, all the proceedings shall be held in camera. And the end of the article says that when the petition has merit or not, the Chief Justice will have her say by herself or a lawyer appointed by her in this case. So at that time, how can she participate in the discussion without having access to the petitions that have been leveled against her in terms of stated grounds for removal, incompetence, what? So when the committee is sitting, and at that time, the Chief Justice will not have access to the petition, whether it is meritorious to the status of removal or not. So for now, as I said, it is premature.
No.
Otherwise, why did the petitioners not go public?
So
why did the petitioners not publish their petition in the press? Why? Because they are also going by the constitutional provision that all proceedings must be held in camera. So if you leak what you have sent to the president, to the council of state, and then a committee, then what is the merit for it? By way of in camera. Okay. That's why I said that she will have access to the petitions so that herself or the lawyers that she appoints to represent them will now go into them to see whether they merit the status of removing a chief justice
or not. Okay, very well. Very well, Prof. Viewers, we'll take a quick break. The conversation is getting interesting. We'll be right back. Don't go away.
This is the time, no more delay. Yes, yes, yes. I'm so excited. This is the time. No more delay. Call a friend to call another that it is time for the young people to connect right here on WTV. Welcome to Y Connect, where we connect youth to Christ. The future is here.
Oh yes, the solution to all your travel needs is here. 𝗟𝗡 Lodge and Travel Services offers you the opportunity to travel to the following countries: Canada, United States of America, Turkey, Dubai, UK, Australia, New Zealand, Malta, Germany, and other European countries, where skilled workers such as nurses, paramedics, nannies and caregivers, drivers, plumbers, masons, electricians, carpenters, painters, etc. are needed for urgent employment. 𝗟𝗡 Lodge and Travel Services can secure your Schengen visas with work permits. Individuals, organizations, churches, schools can contact us for their ticketing and hotel reservation, car rental services, international tour packages, travel consultation, visa assistance, and study abroad packages to all countries. We are located at Mr. Bates Bus Stop, opposite the Calvary Baptist Church at Abaka, Ankrah, or contact us on these numbers: 0544-279525 or 0545-622-672 or 0302-237557. 𝗟𝗡 Lodge and Travel Services, your destination, our pride.
Welcome back. You are still on the state, and this afternoon we are looking at the petitions for the removal of the Chief Justice. We've been looking at it, examining the move that has been made by the President. Is it the procedure that has been adopted? Is it legal? Is it appropriate? We've had guest experts on the subject helping us to understand and appreciate the conversation. He's been with us on the phone. He is a socio-political analyst, Professor Nana Osei PhD Anto. He's been helping us to understand and appreciate. And we also have in the studio a private legal practitioner. He's J.B. Afrifa Esquire, also coming strong on the position of the law and the Constitution. Very interesting, intriguing that we quickly had to take a break and then come and make sure that you join the discussion, the conversation going on, the historical part of it, the sociology part of it, and then also the legal education bit of it. So we're still looking at it. So before we went on break, we had to look at what the Article 46 says, then how the whole thing, viewers are not privy to the content of the petition because the architecture of the Constitution is such that these things must be held in camera. It's not the Chief Justice, has she the right to request that she is heard in the process of the president consulting the Council of State. We've looked at all these issues, the prima facie case that has to be established. We've followed through critically and carefully. I want to believe that by now you are with us and you are trying to understand and appreciate the conversation concerning the call for the removal of the Chief Justice. Now, let me start with you, JB. The removal process. How is it like?
Yes. So the process, as I have already stated, is clearly captured under Article 146 of the Constitution, and in respect of the removal of a Chief Justice, it comes with a petition, as I said, which should be on the grounds of a stated misbehavior of the sitting Chief Justice, or incompetence on the part of the Chief Justice, or the inability of the Chief Justice to act by reason of infirmity of body or mind. Now, this petition should be submitted to the President. Now, the President would have to establish a prima facie case that the petition has merits, and on that basis, the President would, in consultation with the Council of State, appoint a 5-member committee.
Just a minute, hang on. Help our viewers to appreciate prima facie case. What case is that?
Yes, so the prima facie case is a preliminary decision that you take that the issues presented before you warrants an answer.
Okay.
So it's deeply rooted in our criminal jurisprudence, such that we say that in criminal matters the burden is on the state to prove. Now, after the state has led their evidence, the court would establish that there is a prima facie case, meaning that the elements of the offense for which you have been arraigned have been established by the state. So in this instance, the President, in establishing the prima facie case, would establish that the grounds upon which you have to bring a petition for the removal have been established with the facts that you have presented. And so looking at the petition, the President could either see some merits on the ground of stated misbehavior, or some merits or some facts that allude to incompetence and all those things. So that will be the ambit of the President establishing a prima facie case. Now, if that is established, that there is a case to be answered and there are merits in the petition, the 5-member committee of inquiry would be established. Now, the President makes such an appointment in consultation with the Council of State. 2 of them should be justices of the Superior Court, and 1 of them will be the chairman of such a committee of inquiry. Then there will be 3 others who will be appointed, who should neither be parliamentarians, members of the Council of State, or even lawyers. So they should be lay persons. And I believe that this is deeply rooted in the administration of justice in our country, which Article 125 clearly says that justice emanates from the people and shall be dispensed in accordance by the judiciary on behalf of the people. So the justice emanates from the people, and so that's why we have the jury systems where lay persons assist the courts in determining issues.
So these 3 lay persons who have to be part of the committee that will inquire into the petitions, yes. How are they selected?
So it's entirely at the discretion of the President and the Council of State. They will make this appointment of these 3 persons. Now, when they are appointed, then they will go into the merits, and it's a committee of inquiry. So they will inquire into all that, take all the evidence that they need, and establish whatever case that it would be. Now, after they are done with their inquiry, they submit their findings to the President, and the Constitution clearly says that the President shall act in accordance with the recommendations of the committee. And so that's where the process would end, that the President will act in accordance with the recommendations of the committee. So if the committee should recommend that they find no merit in the petition, and so the Chief Justice ought not to be removed, so be it. If they find that the Chief Justice is culpable of some stated misbehavior of incompetence, and the President would act in accordance with those findings. Now, there is a crucial point here and a constitutional requirement which we haven't so much touched on, but it's very important, that when a petition is referred to the committee, the President has the power to suspend the Chief Justice. And so that's why the establishment of the prima facie case is so crucial, because the moment the committee is formed, the President has the power to suspend the sitting Chief Justice. And I will read in clear terms of Article 14610, where a petition has been referred to a committee under this article. The President may, in the case of the Chief Justice, acting in accordance with the advice of the Council of State, by a warrant signed by him, suspend the Chief Justice. So, in order that the office, the esteemed office of the Chief Justice is safeguarded, that is why the establishment of the prima facie case is very crucial, that we do not entertain any frivolous actions just to push it into the formation of a committee of inquiry where there is no basis, where a prima facie case has not been established, just for the President to suspend a sitting Chief Justice. It could be a tool, and it could open the floodgates such that the work and the professional duties of the Chief Justice can at all material times be interfered with. And so that's why a lot ought to go into the establishment of the prima facie case, and that's why it's crucial for the Chief Justice who is named to provide preliminary comments on the matter even before a committee of inquiry is established, because you realize that the moment the committee of inquiry is established, we are already getting done with the matter. The moment they establish it and they make their findings, it goes to the President, and that's final. And so there is a lot of work that should go into the preliminary stage of establishing the prima facie case. And with this case of the Chief Justice request being premature, I would say that we all know that the Chief Justice, in the exercise and execution of her duties, a lot of processes come to her, but she's taking an oath to keep all these processes confidential. And so we cannot make the point that the President is refusing to furnish the Chief Justice, who is a subject of this petition, a copy, because the moment it gets to her, it's breaching the in-camera proceedings. The moment it gets to her, she is also to keep it in camera, respond in camera without leaking it. And so we cannot say that the moment it goes to her, then it's out there. She has a duty to keep it confidential as required by the Constitution.
Okay, Prof, we are in the dying embers of time, but let me pick your thoughts on this. So under President Akufo-Addo, after President Akufo-Addo, we have 3 Chief Justices. We had Sofa Akufo, we had Eni Yeboah, and then Gertrude. 3 appointed by one president under him. Between 1977 and 86, we had the issue of Justice Fred Uredu, where we had a similar incident where he had to be made to go and visit a parliamentary vetting committee, and then when it came, he wasn't recommended for the role of Chief Justice, and he had to more or less appeal. I'm asking that, is it a matter of politics? If I come, I have to change the Chief Justice. Is that the situation we find ourselves in politically?
Yeah, politically it could be true. Politically, but if you want to act mischievously by your position as a president, then it exposes you. Otherwise, if you're a president who wants justice to actually run the way it should run, then let the course of justice by constitutional provisions work. My legal friend was talking about prima facie case. Go to Article 146.3. It is only when the Chief Justice is not involved, but she or he is acting, that is where the Constitution specifically states that there's a need for a prima facie case to be established. In the case of the Chief Justice herself, by Clause 6, there's no need for a prima facie case. There's not. Please let's look at it critically, because you're talking about those below the Chief Justice, which ends in Article 146.5, where the Chief Justice must establish a prima facie case before they go into the merits or not of it. But in her case, by Clause 6, there's no need for a prima facie case. When the President establishes the committee through the Council of State, then the committee takes over, not even the President. Because if you go to 9, it says that the President shall, in any case or in each case, act in accordance with the recommendations of the committee. So here the independence of the Chief Justice is preserved. And then at the end of it all, when the committee establishes, or in the course of establishing whether the Chief Justice must be removed, there even it is not a, but presumably, then she must be suspended, not removed.
Okay, very well. The conversation.
So when she is suspended, then they can have a free will to now establish whether by the provisions of the Constitution she should be removed or not. Then it comes to the ball of the president, who acts on behalf of the people.
Yeah, thank you very much, Prof. Thank you very much, Prof. We final words in a second. The conversation has just begun. I'm sure we'll visit it again as it progresses. JB,
my final words will be that the judiciary is the only arm we have, and I will make the point that we should not descend in the arena of judicial functions with our political sentiments. We have to maintain their independence, and it shouldn't be about President A has come and so he has to change a Chief Justice who will work for it. And so we shouldn't put our political sentiments when it comes to matters affecting the judiciary.
Thank you very much, lawyer 𝗟𝗓𝗩𝗘 Esquire, for your thoughts on the discussion. Thank you also very much, Nana Osei, PAC Anto, socio-political analyst. Thank you, gentlemen, for joining the conversation. Thank you very much, viewers. Make a date with us when we are back after the holidays. Happy Salah. I'm Gabriel to Ankrah. Goodbye.